The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Morning, welcome to the Fourth Circuit. Please be seated. Judge Keenan, can you hear us all right?
Yes, I can, Judge Agee. Thank you.
All right, good to see you. We're ready to have argument in our first case, Maryland Shell Issue versus Moore. Mr. Nardone, we'll be glad to hear from you.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. My name is Mark Nardone. I'm here today to argue on behalf of the plaintiffs and appellants in this case. At the outset, it is critical that we distinguish what is and is not at issue in this appeal. This appeal is not about the constitutionality of background checks. This appeal is not about the constitutionality of what may or may not be required of an individual seeking to carry a firearm in public. What this case is about is whether or not the government may require law-abiding, responsible citizens to obtain permission from the government to be able to undergo a background check that permits them to acquire a handgun. Your Honors, under the standard that was set forth in
can I ask you that why are you going that far? Right? Because it seems like to me that your argument instead is that they can't do this, right? Which is a narrower question, right? You said they may require permission at all, but what they've done here is they're requiring permission after waiting 30 days.
It is,
and so it might well, at least help me understand, it might well look different if that permission was virtually instantaneous, right? So if there was a computerized background check that was done in some form or fashion that was virtually instantaneous, didn't require them to leave the store, for example, that might be a different constitutional problem than one that takes 30 days. Is that?
That's absolutely right, Your Honor. And it's also critical that the handgun qualification license, what is at issue in this case, does not allow an individual to acquire a handgun in Maryland. And that's why I think it's important to start with the statutory scheme here of what exactly occurs when a law-abiding citizen seeks to acquire a handgun in Maryland. In Maryland in 1966, enacted a law that required enhanced background checks for individuals who wish to purchase, at issue here, handguns. That involves the provision of a social security number, a driver's license number, your address, all manner of identifying information. It requires a 7-day waiting period. And it also, as of 2000, required a viewing of a 1-hour video. All of that is still required. And that is the process that an individual who wishes to acquire a handgun needs to undergo. And that I believe,
just so I understand, you have not yet challenged that requirement.
That has not been challenged, Your Honor. That is not at issue in this case whatsoever. At issue is the law that was enacted in 2013. In 2013, this.
So to be sure, I understand the factual context here. If I'm a citizen of Maryland and just suppose someone has threatened me or my family, and I want to obtain a handgun to defend myself in my own home, I have to wait the 7 days and then the 30 days, be fingerprinted, get the background check, pay the fee before I can obtain the firearm.
It's actually an even longer process than that, Your Honor. The way that it works in Maryland currently is that before you are able to file an application for a handgun qualification license, you are required to attend training that lasts a minimum of 4 hours and can only be conducted at a location that allows for the discharge of live ammunition, thus prohibiting in the major city in Maryland, Baltimore.
Who pays for that?
That is paid for by the individual seeking the license, and the fee is set by the trainer. It is not set by statute. The discovery in this case indicated that the fees can range upwards of hundreds of dollars. After that training is completed, an individual receives a certificate.
How available are those sites?
That would depend on the availability of the trainer themselves. So the way that it is statutorily set up is that individuals are qualified as handgun instructors. They then instruct at locations, and that is dependent on their
Hold on
schedule.
just a second, counsel. Rachel, we're not showing any time here.
Oh, it's up on the screen there, sir.
Oh, I got it. All right, thank you. My bad. Go ahead.
Of course, Your Honor. They are as available as the instructors are. Now, I will candidly admit we do not have evidence in the record as to whether there are gaps, but we do know that there is an issue that individuals who are in Baltimore City, for example, cannot simply travel to a close by site for their training because they must go somewhere that permits them to discharge a firearm under the regulations adopted by the Maryland State Police.
So what about the fingerprinting? Does the applicant have to pay for that?
They do, Your Honor, and that is also not a fee set by statute. The fingerprinting is also required before the handgun qualification license application can be submitted.
Where do you do it?
You can do it at any one of the state's live scan vendors, which are all privately operated, and they can charge whatever fee that they wish.
Okay, Mr. Nardone?
Yes, Your Honor.
I'd like to consider your argument in the context of Justice Thomas's and Supreme Court's footnote number 9 in Bruin. And it seems to me that the court laid out a path for us to consider in terms of shall issue regimes. In other words, laws that have a narrow objective focus rather than the kind of discretion that was at play in Bruin, where the court would make you show just cause and the state could turn you down anyway. And so I think the Supreme Court in footnote 9 was saying that in the case of a shall issue regime, where the criteria are narrow and focused, that there isn't a problem unless there is a too lengthy waiting period or an exorbitant fee. The court seems to leave a kind of a catch phrase at the end saying that there can be conditions that make a shall issue law unconstitutional, even though shall issue laws generally will pass constitutional muster. So take us analytically through footnote 9 and with your argument. Is your argument solely then that these conditions are too exorbitant as to fee and too lengthy as to waiting period, and that's what renders it unconstitutional, and that if the waiting period was shorter and the fee was lesser, it would not be?
Your Honor, I think there's a few things there, and I'm happy to address that. Number one is I think that the test that's set out in Bruin that must be applied in all Second Amendment cases, regardless of the manner in which the evaluation is to happen, is the text, history, and tradition test. And under that test, if the challenged law is a novel attempt at addressing an old problem, it is unconstitutional. If the challenged law could have been enacted at the time of ratification, there's no question that had the government wished in 1791 to enact legislation that would require citizens to obtain permission before undergoing a background check, which establishes whether or not they are a permitted possessor, then they could have. And there is simply no historical tradition of that. Footnote number 9, Your Honor, I would say, does not go as far as to countenance all shall issue jurisdictions or statutes. Rather, it is an acknowledgement that what was at issue in Bruin was a particular problem, the problem of government discretion. And so there's
right.
That number 9.
And do we have government discretion here? Or do we simply have a waiting period that is too long, in your view, and a cost to qualify as too expensive?
Your Honor, I don't think it comes into the purview of footnote number 9 because we are not dealing with the same situation of licensing that we were dealing with in Bruin.
Exactly, and that's what footnote 9 is addressing. It's saying that although the court in the New York statute in Bruin was called to pass on a may issue statute, what the court is saying, nothing in this analysis shall cause us to question the constitutionality of shall issue regimes unless They are exorbitant in fees. In fact, the court even says that fingerprinting requirements and background training are not a problem unless the fees are exorbitant and the waiting periods are excessive. I mean, the court very clearly in that footnote talks about fingerprinting and says that that's not a problem unless there are barriers imposed by the state. So it seems to me that based on this footnote, and tell me why this isn't correct if it isn't, but it seems to me like based on this footnote, there's a different kind of analysis that Bruin needs to be tweaked a little bit, because the majority opinion in Bruin dealt with a may issue regime. We have a shall issue. In other words, if you pass the background check and you pass the training, the state can't say you haven't shown just cause. The state's got to issue it.
Your Honor, I think.
And so so are you agreeing then that footnote 9 puts your argument in the category of saying that the fees are too much and impose too great a burden and the waiting period is too long?
Not at all, Your Honor. I'm saying that this case does not fit within that framework whatsoever, because the license that we are talking about is fundamentally different than the license that was at issue in Bruin. In Bruin,
Right. But I'm asking you about footnote 9. Footnote 9 is drawing the distinction with the majority holding in Bruin.
Your Honor,
And talks about fingerprinting and talks about and talks about training.
Your Honor,
And you haven't addressed footnote 9. Would you please address your argument in the context of footnote 9?
Thank you, Your Honor. In Bruin, the license at issue allowed.
Perhaps another way to ask that question is footnote 9 a generic Second Amendment framework, or is footnote 9 directed to that case, which was a public carry case?
Your Honor, I think that it is different for a number of reasons. Number one, there's obviously a difference between licenses to carry and licenses to possess, because the interests that are at issue are different when you are carrying outside the home and versus not. However, we need to make clear that the license at issue in Bruin permits an individual to carry a firearm as soon as it is issued. And the license here is not that. That is why it is fundamentally different than what was at issue in Bruin. And that is why footnote number 9 does not have relevance to this particular case. What we are dealing with here is not a license that permits someone to acquire a firearm. If you have a handgun qualification license and you receive it in the mail on Monday morning, and you immediately go to your closest federal firearms licensee and you attempt to buy a handgun, you cannot do it. You cannot walk out of the store that day with that handgun. It is not the same license. Rather, what this license does is it permits an individual to undergo the background check that ostensibly determines whether or not they are permitted to acquire a firearm. And we know that because when one goes to purchase it, the provision of the handgun qualification license is insufficient to permit them to walk out the door with their handgun. And so, Your Honor, I don't think footnote number 9 here is controlling, but moreover, I think footnote number 9 is more narrow than that. I think what it is saying is that the issue before the court in Bruin was whether or not may issue licenses are permissible. And therefore, there is no reason for the court's decision to have had any impact on shall issue jurisdictions. I think that is all that footnote number 9 is saying. And at the end, it obviously allows for challenges where a shall issue jurisdiction could still violate the Second Amendment. I think that, Your Honors, is a recognition that regardless of whether this is a may or shall issue case, what the court needs to look at is the effect of the law, and whether or not the effect of the law is to impose an unconstitutional burden on the right to acquire a handgun. And in this case, like every other Second Amendment case, the mechanism by which that determination is made is evaluating the historical tradition of firearms ownership and the rights afforded by the Second Amendment. Your Honors, there is no historical analog, tradition, or anything related to the idea that an individual needs permission from the government to be allowed to undergo the background check that determines that they are in fact eligible to possess a firearm. This is akin to requiring a permit for a permit.
Judge,
Sorry.
Mr. Nardone, briefly before you sit down, is your position that the different requirements of the statute are severable?
No, Your Honor, I don't think they are.
You're saying they have to rise and fall together, and why is that?
I think that the entire handgun qualification license scheme is in fact unconstitutional for the reasons that I said. It is not permissible to require, Your Honor, may I finish? I see my time is finished.
Go ahead, please.
It is not permissible to require an individual under the auspices of ensuring that they are not a prohibited person to first seek out permission from the government to be able to undergo that inquiry. That is what we are talking about here, and that vel non is unconstitutional. But the individual components, the fingerprinting, the class, those are unconstitutional in and of themselves because there is no historical tradition of those. But the entire statute itself is unconstitutional, Your Honor. Yes.
Okay, and let me ask you just one other thing for you to consider on rebuttal. Should this case be remanded to the district court to make the determinations that you're asking a court to make today?
Your Honor, I'm happy to answer that now, but if you prefer, I can wait to rebuttal.
Go ahead. That way your opposing counsel can have the benefit.
Your Honor, no, I don't believe a remand here would be appropriate. We are dealing with a question that involves legislative, not adjudicated facts. This case was briefed after Bruin came down. The government was able to provide whatever citations to whatever sources that it felt was necessary to meet its burden under Bruin to demonstrate the constitutionality of this case. On remand, any issue would be under the same evidence that it would have presented here, and any appeal from that remand would be de novo by this court. I don't see any situation in which a remand would do anything other than waste judicial resources to arrive back here at the exact same posture that we are now. Your Honors, unless there are any other questions, I would reserve for rebuttal.
All right, you've got rebuttal time. Thank you, Mr. Dietrich.
Your Honor, may it please the court.
Can you start with the last two questions that Judge Keenan asked of your colleague? And the first being, who bears the burden to establish severance? Have you argued that this statute is severable? And if you haven't argued it, can you help us understand why we should consider a severance or severability argument at this particular stage? And then second, the question that Judge Keenan asked your colleague about remand. I noticed in your brief here, you did not ask for a remand. At no point did you request a remand. And it stands in stark contrast with the same brief or similar brief you filed in Bianchi within a week of this brief, where you did ask for a remand. And so I sort of take that as been a conscious choice to not ask for a remand, given the proximity of two briefs from Maryland, both addressing Second Amendment cases, both following Bruin. But wanted to give you a chance to comment on both of those.
I'll take the remand question first, which is that to the extent there's evidence necessary to resolve the question, I think it's in the brief and in the record below. There was discovery. There was no discovery in Bianchi, none at all.
No, I understand. I think that's right. I just wanted to make sure that I wasn't missing something from your end.
Right, but your discovery was before the Bruin decision.
In this case, yes. Yes, it was.
So there would have been no reason to have elicited the information that Bruin would seem to require.
But I think we're talking about two different things, possibly. In Bianchi, we were talking about evidence of the historical tradition at issue there, and whether there were statutes that supported restrictions on types of weapons, and that was the.
And also the empirical question of whether these firearms were in themselves in common use. I mean, that's an empirical question that evidence had not been developed on in the record below.
That's correct. And their utility for self-defense and things of that nature that went to that historical tradition. Here, the discovery down below was about the whether this burden was onerous on the applicants. And what the evidence showed was that when we compared pre-HQL, pre-Firearm Safety Act of 2013, and post that act, we saw that people were getting handguns at a higher rate.
How does that relate to the Bruin stand?
It relates to the Bruin standard because, well, there's a few Bruin standards, I think, floating around here. The Bruin standard of history and tradition is one thing. The Bruin, what we'll call.
And you've got to cross that bridge first.
And I understand that. And
your
other-
brief seems quite sparse on historical analogs in the founding era.
the historical tradition here, I see, Judge, I'll answer your question.
No, please, I'm sorry. Answer Judge Agee's question first.
The historical tradition is the substantive limitations that are furthered by the HQL law. And those are ensuring that dangerous, subversive, non-virtuous, however you want to describe it, folks do not get deadly firearms, and ensuring that the tradition of firearm competency that was alive and well at the founding and before that.
What founding era analog do you have from any of the states that a citizen was required to have a permit from the government before they could have a handgun in their home?
The historical analogs relate to the substantive limitations that are part of the robust historical tradition of the Second Amendment.
Well, why don't you give us an example?
We look at laws from the founding that related to individuals who were required to take a loyalty oath or be disarmed at the time of the founding. We look at.
But that's after the fact, right? So that's, if you don't do something, we're going to take your gun from you, right? So, for example, if you commit a felony, we will then require you to turn your guns in. All right, that's fine, but that's not pre-clearance, right?
No, and I understand that. If I could just get out that when I talk about two Bruin standards, the second Bruin standard is the one that's in footnote 9.
Right. So I want to go there. I still want you to come back and talk to me about whether you've tried to assert severability. But if you want to go to footnote 9, your argument, as I understand it, is that footnote 9 is an exception to Bruin's history and text test. Is that we don't have to look at history and tradition, that the whole opinion in Bruin carves out an exception in footnote 9 and says a different standard applies. Is that how you're asking us to read footnote 9?
No, it's not. How we're asking you to look at it is that we want you to look at history and tradition. Bruin commands us to do so. And that history and tradition is talking about how it's furthered by the HQL license in respect to two historical traditions. One is restricting those who are dangerous or contrary to public safety from getting handguns. And two, a robust historical tradition of firearm competency and requiring responsible citizens to be trained in the use of firearms.
So what's that have to do with the analogs they talk about in Bruin? I'm still waiting for any remote founding era statute that had a restriction similar to what we have here.
And I understand your question.
Well, do you have one or not?
We do not have any. We were unable to find any that required advance permission. But when you look at what Bruin is saying, Bruin is giving us the roadmap in footnote 9 about what states are able to do vis-a-vis substantive
separate from history. So in other words, you have no history, but this footnote which says this other case exists out here that's not before us, that you want us to apply that standard instead of the 50 pages of analysis that the court actually engages in. Like skip the history and just use this exception to the Bruin test.
We are not saying it's an exception to the Bruin
test. I think you are. I mean, I know you don't want to use that word because it's pejorative, right? Like I'm using it for that reason. But how is it not an exception if you're saying, yeah, we've got no history, but look at footnote 9, right? But look at footnote 9. It creates a different path, right? I think earlier it was referred to as a different analysis, right? Was the statement that was made as different analysis that's in footnote 9.
But the Bruin footnote 9 path requires history and tradition as a fundamental premise of the substantive limitations that are being addressed there. And I think that's the message that Justice Thomas, the majority in that case, and Justice Kavanaugh and the Chief Justice in the concurrence were saying that when you have substantive limitations, you can have procedural mechanisms to enforce them. That's what Judge Easterbrook said in the Seventh
Can
Circuit.
you turn to the severability and just help me understand? Do you make the argument that the statute is severable? And do you agree that it's your burden to do so?
We didn't address severability in our briefing. Our position is that the law is constitutional as is because it is a regulatory scheme
But it rises or falls together.
I think that's
Mr.
Judge
Dietrich,
Keenan has a question.
yeah, Mr. Dietrich, you can't concede an issue of law as to severability. But I want to ask you a question about that. It seems to me that, and I think Judge Richardson makes a really good point, the Supreme Court is not taking back the requirement of historical analysis. I suggest to you that what footnote 9 is doing is saying that in a case you have a shall issue regime and the criteria are narrow and objective, then you have to make a determination of infringement. The Second Amendment talks about infringement. And they didn't have to consider nuances of infringement in Bruin because the government controlled everything. It had complete discretion, so automatically there was per se infringement. But here, the issue of infringement has to be considered along with historical tradition. Seems to me that that's what they're saying. And if that's the case, and if evidence on remand shows that there is a historical basis for keeping dangerous people from having weapons, but there is no historical basis for requiring training of firearms, why wouldn't the statute be severable?
Your Honor, I just admit I'm not necessarily prepared to address severability. It wasn't something that we argued.
Okay.
I mean, if I would hate to.
Can I ask you about, Judge Keenan asked you about infringement. And one of the arguments you seem to suggest here is that this doesn't infringe on, Judge Agee's hypothetical, law-abiding citizen who's threatened and wants to buy a gun to protect himself. He's got to wait 30 days plus, right? Exactly what the number is, doesn't matter. 30 days for this, 7 days for that, something else for another thing, but 30 days plus. Is your argument that that time period where he cannot buy the firearm to protect his family and his home is not an infringement of his Second Amendment rights, the law-abiding citizen's rights, right? Not the person that you claim you're targeting, but let's posit hypothetically that he's a law-abiding citizen and he wants to protect his family and he's got to wait 37 plus days to get it. Is that not an infringement of Second Amendment rights?
Well, first, I just want to push back on the 37 days. The 30-day in the statute is actually is a maximum that can exist.
All right, you want to call it 13 days. Pick a number you want to, right?
Sure. I just wanted to make sure that was understood.
Whatever number you want to pick, right? 13 days. If you had to wait 13 days, is that not an infringement?
It affects Second Amendment rights in the sense that
it denies him his right for 13 days, right? He has no right to possess a firearm for 13 days.
And that's correct, but it's
and is that's what I'm trying to get at. Is that an infringement of his Second Amendment rights?
No, because what you're saying is a legal conclusion. I don't want to argue semantics, but it affects his rights under the Second Amendment, but does not infringe them.
All right, so let me ask a different question. So imagine you've got a community and you think a crime's about to occur. And so you go to that community and you round up everybody in the community and you put them in prison for 30 days or 13 days, right? And you say, somebody here is bad, right? Most of y'all are great. You're law-abiding citizens, but somebody here is bad and you might be planning to do something bad. Wouldn't we say that's an infringement of their Fourth Amendment rights?
Certainly they would.
Right? So the law-abiding citizen, just because it's 13 days or 30 days, doesn't mean that it's like de minimis, right? And so you're only in the pokey for 30 days, right? We would say that's an infringement of the Fourth Amendment, right? Even if it was designed to protect the public, right? Because we're concerned about what these two people might do. We don't know which two.
Well, I think the answer perhaps boils down to the fact that these constitutional rights were enshrined with the understanding that they had at the time of founding. And so when you look at the Fourth Amendment, right, it protects public safety, but it really protects the individual from unreasonable search and seizure. And then you look at the Second Amendment, you look at the distinct history of the Second Amendment, going back to the
And
English Bill.
it doesn't protect the individual, is your argument.
It certainly protects the individual, but it doesn't, perhaps not in the absolutist sense.
Well, neither does the Fourth Amendment in the absolutist sense, right? It's not absolute, it's a question of reasonableness, right? It even has reasonableness built into it. But nobody would say that like putting the guy in prison for 30 days or all citizens for 30 days, just so we can try to figure out if there's a bad apple in the bunch, wouldn't be an infringement of the Fourth Amendment.
No, and if reasonableness is the touchstone, then I think
It is in the Fourth Amendment. There's no reasonableness carve out for you in the Second Amendment. The Second Amendment is more absolute than the Fourth.
Well, I think that to the extent there's a reasonableness in the Second Amendment, it's reflected in the history and tradition. And that's what the state is relying on and going back
So
to.
tell us succinctly, what is the history and tradition you keep referring to?
Preventing dangerous individuals from obtaining deadly firearms.
That's a generic concept. I guess you've already admitted you have no founding era statute that's an analog to what Maryland does here.
We were unable to find any, but look at the Bruin footnote 9. The Bruin in the body of
And I
Bruin.
take it you read footnote 9 as a comprehensive test for all Second Amendment cases, and it's not tied to the public carry context of the Bruin case.
I agree, and I look at footnote 9 as just.
Well, that was a question. I wasn't positing one way or the other.
But the state looks at footnote 9 as an extension of just generally applicable constitutional principles that say when you have substantive limitations built into a right, you can have legal mechanisms to enforce them. And that is what Bruin footnote 9 says, is that you can ensure that law-abiding responsible citizens are the only ones who bear arms in the jurisdiction by having upfront background checks, fingerprints, firearms training, mental health evaluations or checks. And Bruin, in its vast historical analysis, yes, it went to the substantive limitations on public carry. But then when it comes to footnote 9, they don't have that same any sort of historical analysis. They say it as if it were just something that we take for granted. And it kind of is, because it's part of the generic constitutional landscape. You can see that in voting cases. We have voter registration. We have photo ID laws that this court has approved of. And what are those but ways of beforehand ensuring that the substantive limitations can be enforced? And so that's the way that this case should be viewed. Is that
Okay, excuse me, Mr. Dietrich. The Supreme Court in Bruin, in the majority opinion, was addressing surety laws that existed at the time of the founding and referenced the fact that they only imposed a de minimis burden on the right to carry. Isn't that correct?
I believe that's correct, Your Honor.
Okay. Why then don't we have to remand this case to the district court to determine exactly what this burden is? I mean, is it a de minimis burden like the surety statutes, or is it something bigger? Apparently, there were restrictions back in colonial times of a different type of restriction on people's right to carry. Why do we want to opine at the appellate level when the district court has never considered this? The district court decided the case under Colby and used the Heller analysis as modified by Colby or as interpreted by Colby. So why do we want to jump in and take this case when the district court hasn't had a chance to see if there are historical analogs? Just because you can't come up with them now doesn't mean there aren't any. And it seems that the law is best served when there's an opportunity for evidence to be taken, the case to be played out under the proper analysis, which wasn't done. The proper analysis was not done because the judge didn't have the benefit of Bruin.
Well, I would agree that if this court is inclined to take that path, then yes, it should be remanded for that consideration.
So what do you do with footnote 6, where it says, the Supreme Court says courts are entitled to decide a case based on the historical records compiled by the parties, right? That the district courts, not under an obligation to go to the Library of Congress and flip through the statute books, right? We're not required to do that independent of you, right? We rely on you. And so you've compiled, and this is not a critique of you, right? You've done, I'm certain, the best you can do, but we're entitled to rely based on the record compiled by the parties.
Yes, you can rely on that. That's what footnote 6, that's correct, in Bruin says. But it's always been our position that there is a historical tradition in the substantive limitations that this statute furthers. And with regard to the burden, the administrative burden, the district court already opined on that and said that this was a de minimis burden. And so
right, but the district court did that under an entirely different analysis. It was a pre-Bruin analysis.
I understand. If this court is inclined to remand,
and it was, excuse me, it was an analysis that the Supreme Court expressly rejected in Bruin. They said that we're not going to have this kind of balancing test. And that's exactly what the judge did, because she didn't have the benefit of Bruin. So why would we then try to cobble the law here without giving the district court the first shot at analyzing the case under the existing Supreme Court precedent?
Your Honor, I'm certainly not going to stand in the way if that's what this court needs to decide. And our position is that the district court did decide that, said this was de minimis. With respect to the burden itself on applicants, everybody who is law-abiding, responsible citizen can get an HQL. It's a shall issue regime. And Your Honor, I see my time is up. Is there any other?
So, I mean, I understand why you taking the position to affirm, but I guess this is neither here nor there, but I would have kept looking in your brief for an alternative prayer for relief that if we disagreed or following Judge Keenan's line, that we would remand. I'm just curious why you didn't plead that in the alternative.
Because there was a robust, frankly, there was a robust record down below that presented evidence on what we believe to be the only issue that was in terms of an evidentiary issue, which was what is the administrative burden on applicants? And that evidence is there. How many people were able to get HQLs? How long it took, what the costs were, and all of those were available for the district court. And again, the state wouldn't stand in the way of this court remanding if this court believed that it needed additional evidence or different evidence to decide the case.
Thank you very much.
Can I ask one follow-up question? I just had one factual question. You seem to rely a number of times on this idea that the HQL was associated with a decrease in homicides in large urban counties in Maryland. You remember this, the sort of argument? But you do that excluding Baltimore City, which is also a county. I know that's confusing. Baltimore City County. But Baltimore City County is like 70% of the murders in those counties, right? So it seems odd to say it's associated with a decrease in these 3 counties, but 70% of the murders happen in Baltimore City County in Maryland, and that increased when the HQL came out. Can you help me understand how you seem to rely on that as sort of evidence that this works, but when you put the numbers together, it's actually associated with an overall increase in murders in Maryland. And I'm just trying to understand, you seem to rely on it. It seems to cut the other way. Can you help me understand that?
Sure. That distinction was made basically because of the uptick in crime in general in Baltimore City after the unrest, after the death of Freddie Gray in 2015.
Right, but it's remained like, in fact, the murder rate in 2020 is higher than it was in 2015, right? So that would, excluding Baltimore would make sense if it popped up and there's this unique instance and then it decreased again. But instead it's remained at indeed higher levels than in 2015. So excluding Baltimore City from the question of association, which obviously correlation is not causation anyway, but it seems to get the analysis like absolutely backwards.
Well, you're getting into areas where I feel I'm not qualified, but one way may say that the effects.
Yeah, I don't think the expert was qualified either. And that's sort of part of the rub that I've got. I mean, I think he's like just pulling data, right? If you create a correlation by taking out 70% of the data, that doesn't look like actual statistical analysis.
But where I was going is I think that the effects of that unrest from 2015 are still ongoing, still very much ongoing. And so you're still seeing the effects even through 2020, which is where the data stops in the record below. But it's just social scientists reflecting factors that they felt were outliers and that skewed the data. And it's there for the purpose, both pre-Bruin and post-Bruin, to show that this law has an effect. And so it furthers that substantive limitation, that historical tradition of keeping guns out of the hands of dangerous people, and that it works, because I think that's part of the holistic analysis of that second prong of the Bruin footnote 9 test, which is this an onerous law in terms of, does it diminish or extinguish the right? Is it too onerous? And if it's something works, if something is shown to work, be correlated with something that works, then that is part of the analysis in terms of whether it's too onerous. Thank you. Thank you.
All right. Thank you very much, Mr. Dietrich. Mr. Dardenne, you have some rebuttal time.
Thank you, Your Honor. Briefly, I would like to just address a few of those points, starting with a point that Judge Keenan made that is absolutely correct. Bruin did away with the balancing test that had been adopted by most of the circuit courts, including this court in Colby en banc. And in doing so, it rejected the idea that the extent of the burden has to be weighed against what government interest is being effectuated and whether or not it is effectual in advancing those interests. And that is precisely what the government is arguing here. Whether or not the burden is de minimis or is extensive or anything along those lines is not a relevant concern under the Bruin test that focuses on the history and tradition and whether or not there is an historical analog to the law that is being considered. Here, the state has already admitted that there is no historical analog for this type of law. Instead, they retreat to the individual component parts, which, as the state has already said, cannot be severed. However, those individual component parts still do not have this historical basis that the government says that they do. For example, the state relies on the idea that individuals will be trained when they showed up for a militia muster. And that is absolutely correct. That was the point of showing up to the militia muster. However,
can you help me for a second? Can you help me? I understand that severability is maybe not at issue given where we are. But do you contend that if the law just required a fingerprint to buy a gun, which is not this law, I totally get, but it required a fingerprint to buy a gun. So you had to either at the store or bring in a fingerprint card, that would necessarily violate the Second Amendment?
No, I'm not sure. I think it would depend on how that law was structured and what exactly was being done with the fingerprinting. I know here that.
Well, Mr. Nardone, I think you need to answer the question though, because what if the law required fingerprinting and to determine whether or not you were prohibited by law from possessing a firearm, such as a prior felony conviction? And what if you were required to just bring that up to the counter to show that you passed the fingerprint check? No waiting period. You passed the fingerprint check. Would that be okay?
I don't think it is, Your Honor.
Why not?
Under the Fourth Amendment, the government cannot compel you without a warrant to provide your fingerprints. The Supreme Court has already held that you cannot condition the waiver of one constitutional right to be able to exercise another. And for the,
Well, you know, the Supreme Court, though, seemed to think that fingerprinting could be okay. If you look at footnote 9, it clearly doesn't agree with you that fingerprinting is a compelled seizure of the person. There's no way to reconcile that statement by you with footnote 9. So your answer is that you just cannot, the state cannot require you to present a fingerprint card that's been stamped okay.
I don't think that is, I think that's correct, Your Honor, and I don't think the court considered whether or not fingerprinting could be okay. In footnote number 9, it listed, among other things, parts of firearm regimes that were not at issue in that court. To the extent it discussed anything, it was discussing whether or not a shall issue regime could still be subject to constitutional challenge.
So wait, just so I understand that, and so Judge Keenan's hypothetical was different from mine, but to go back to my hypothetical, where you just have to be fingerprinted. There's no background check that's happening ex ante. It's not a pre-clearance. You just have to submit fingerprints. Your argument is not that that violates the Second Amendment, but that might well violate the Fourth Amendment.
Your Honor, I would say that it presents the inappropriate choice of which of your fundamental rights you can insist on asserting against the government. Either you can insist on your right to be free from a seizure and present your fingerprints, or you can insist on your right to possess a firearm in the home for self-defense, but you cannot do both. And that, Your Honor,
And you think that's different? You think that's different from like a driver's license, right? That the driver's license would be okay, but the fingerprints are not?
I do, Your Honor. Absolutely.
So, Mr. Nardone, you're saying that in your scenario, then a convicted murderer, someone who'd committed several murders but had been released on parole, could not be blocked from obtaining a firearm under any scenario by the state.
Absolutely.
Fingerprinting requirement or anything else. The convicted murderer should be able to get a gun. Murdered his whole family, right? But he can still get a gun?
Absolutely not, Your Honor. As I said, we're not here challenging background checks. Background checks can and have been done without fingerprints for decades. And in fact,
okay, so how long can a background check take then to not constitute an undue burden on the exercise of the Second Amendment right?
Your Honor, I think that depends.
Is a 30-day waiting period for a background check unconstitutional in your view?
I think it almost certainly is, Your Honor. And also here,
okay, what would meet constitutional standards in your view then for a background check in terms of time?
I don't think that the time alone can be the manner in which we judge these unless the time becomes so long as it is designed to
delay.
But why not? Why wouldn't you say, arguably, right? I mean, all these are hypotheticals, right? We don't have them in this case, but why wouldn't you say, listen, so long as it doesn't interfere with your right of self-defense, then that might be the type of a delay that's permissible. And what time would that be? Well, that'd be the time in which you would remain in the store, right? So if you're at the gun store buying a gun and it takes them a half an hour to run your information through a background check, you're in the gun store, your right of self-defense is relatively well protected. We think otherwise. And so that might be enough. But if you have to leave and go home, right, as soon as you have to leave, then your right of self-defense has been infringed.
Well, I think that's the correct lens with which we have to review these things, because just simply saying something is a background check or labeling that way is insufficient. We have to look at the mechanism that's being applied and the effect of it. And so, to Your Honor's point, someone that goes through a NICS check over the phone, the mechanism there is a phone call, and it effectuates a 5 to 10 minute wait. Here, the mechanism is something substantially larger.
Okay, Mr. Nardone.
Far gone over my time. I apologize for that.
Yeah, let me ask you then.
Answer Judge Keenan's
Yeah, let me ask you then about Justice Kavanaugh's concurring opinion with Justice Roberts, when they both said that fingerprinting is essentially a legitimate requirement of the state. How does that affect your Bruin analysis? Because they joined the Bruin opinion. They have a concurring opinion, but they're saying that essentially fingerprinting is okay.
Your Honor,
And those were two members of the court.
It worked, Your Honor. That's exactly right. It was two members of the court. That opinion did not command a majority, and it is not part of the holding of the court. And in fact, the fact that they would address this separately in a concurrence demonstrates that it is not the way that the majority opinion is to be interpreted. Else it would have been in the majority opinion.
Well, it was in footnote 9, wasn't it?
Sorry, Your Honor?
It was in footnote 9, wasn't it?
Your Honor, I don't think footnote 9 goes that far. I don't.
Okay.
But more importantly, the concurrence is directed at shall issue carry regimes, which are not at issue here and have different considerations when the constitutionality is determined, because there is a different historical tradition of possessing a firearm in the home than there is for carrying a firearm outside of it. Your Honors, unless there are any further questions.
Yeah, one, just so I'm sure factually in Maryland, if I want to go to the gun store in Maryland and purchase a handgun, today I would have to have this handgun permit in hand. I get to the gun store, but to make the purchase, I have to go through an entirely separate process of background checks and all that stuff to actually purchase the firearm.
That's correct, Your Honor. The process starts when you decide you wish to purchase a firearm. At that point, you need to take the time to schedule a course, go get the fingerprinting done. After that's finished, you can submit your handgun qualification license application, which starts the 30-day window. After you receive your handgun qualification license, you then have to go to the store and fill out what's known as a 77R form. Then that is submitted to the state police, and that starts the next 7-day waiting period. And so
it's 37 days. It's 37 days is total.
37 days from the day that you submit your handgun qualification license application if the statutory strictures are abided by, that's correct. However, you have to start the process before that because you have to obtain the training certificate and the fingerprints before you can submit the application.
So in order to actually purchase the firearm, as I think it is true in basically every state, then that separate process will detect the felons, people that are subject to mental detention orders, domestic violence orders, all those sorts of things. That would be detected at that point before you could actually purchase the firearm.
That's correct, Your Honor. And in fact, that carries another $15 fee.
Anything else?
Thank you.
All right, thank you very much. We're going to come down and greet counsel, and then we'll move on to our second case. This morning, I understand we have a group here from the William and Mary Law School, so we're glad to have you. And when we finish argument in our second case, we'll adjourn court and then we'll stay here for a short period if you'd like to talk with us. So with that, we'll hear argument in our second case, United States versus Robertson. Mr. Groen. We'll be glad to hear from you.
Morning, Your Honors. May it please the court. I represent Christopher Robertson. This was truly a protracted litigation resulting from one indictment, two superseding indictments that actually charged felon in possession count, for which he was convicted at a trial, received 30-month sentence, several Hobbs Act related charges, including the conspiracy, 2 attempted robberies, and 11 completed robberies, for which he received 210 months, and 8 firearm brandishing counts, 2 of which were dismissed at trial. The other 6 resulted in convictions, and he received 42 years in sentence for a total sentence of 62 years. The trial of Mr. Robertson, or the trials of Mr. Robertson, were actually 3 separate trials, counting 2 attorneys, 2 judges. His first appearance was actually on June 8th of 2018. His sentencing was on August 12, 2021. And the trial, which resulted in the Hobbs Act convictions, was actually took place on March the 1st, 2021. First trial held in the Eastern District of Virginia right after the COVID restrictions ended. This appeal raises 5 issues. Some of them have 2 sub-issues. Some of them are more important to me. Some of them are more important to you, and I'm sure I'm going to hear which ones they are. Quite frankly, the ones that are more important to Mr. Robertson and me are the ones that drive the sentence. So the first issue is a denial.
Were you trial counsel?
I was trial counsel for the trials that resulted in the convictions. There was another trial counsel for the first trial that resulted in the mistrial. Ms. Bashar for the United States was not trial counsel. Mr. Hurt for the government, who's out there in the audience, was the trial counsel along with Mr. Osip. So I was the trial counsel for both the felon in possession count, which was severed on Mr. Robertson's motion. That was on March the 3rd, I believe, 2020.
In view of the time, you may want to move directly into the merits of the issue.
Yes, sir. There are 5 different issues. I'm not going to.
Why don't you start with your best one?
I will try to do that. I had actually had a long brief with the 4th Circuit one time, and they told me it was too long. And they told me keep it to 50 pages, and I asked the court to get the best 50, but they told me no, you got to do it. So I'm going to get the best issue. The best issue, I believe, are actually 2. The issue, actually 3. The speedy trial violation. The government claims that.
All right, start by explaining why you didn't waive it by statute for failing to dismiss the indictment.
Because the short answer is because under COVID, there was no case law saying that any COVID necessitated.
But what we've said is to raise a Speedy Trial Act claim on appeal, you must file a motion to dismiss the indictment before the district court.
That is correct. That is settled law, and I never did that.
Right. So that's like, it's not just forfeiture. We don't review it for plain error. We don't review it at all. Right? That's like an unreviewable claim. It's waiver. Right? It's not plain error. It's not anything else. It's waiver.
Yes, sir.
That's in the statute. It's not just in
Yes, sir.
language.
All right. So how about what's our next best argument?
The stipulations, Your Honor. Actually, that's the last. The second best argument is this. The instructions that were given to the court, which were not objected, so the review would be by plain error. The instructions that were given to the court were confusing, and they were actually misleading to some extent. And I can go through the instructions specifically. In this case,
Tell me what was not. I mean, maybe they're confusing, but that's not a plain error argument, right? You got to tell me why it is like plainly erroneous. That means contrary to law, and not just contrary to law, but plainly so.
I will attempt to do that, Your Honor. Judge Richardson, in this case, the defendant was charged with a Hobbs Act conspiracy as a principal, with 2 attempted robberies as a Pinkerton liability principle, and with, I believe, 11 completed robberies also under Pinkerton liability. All those charges arise from the same statute.
Is it accurate in the record that that the instructions were jointly proposed?
That is correct.
It's not just a matter of objecting to instruction, but you asked the court to adopt.
They were jointly submitted, Your Honor, and that's the
So
reason.
why isn't that an invited error situation if there is an error?
Because it would be plain error, I believe. And because Your Honor, Judge Keenan, because it affects the substantial rights of, it was error, it was plain, and it affects prejudice, Mr. Robertson, and it affects his substantial rights. And under the standards actually imposed by this court in Hastings and Said, and actually by the Supreme Court in Olano, this court can actually go and correct the error and exercise its discretion based upon the entire record. And if I may, the confusion in this case is that the law had changed. So the instructions for finding liability under the Hobbs Act, 18 U.S.C. 1951, is actually the same. It doesn't matter whether somebody conspires to interfere commerce or commerce by robbery, or does it, or attempts to do it. It's the same thing. The person is guilty. If there is any evidence beyond a reasonable doubt, the person is guilty. The law has whittled down a little bit. So now the courts have said, well, that is true. You're guilty of a Hobbs Act violation, whether it's one of the three, or each one of the three. However, in order for that Hobbs Act violation to constitute a lawful predicate to find somebody guilty of a 924C, in this case, brandishing, it needs to be a crime of violence. And conspiracy to commit robbery by interference with commerce is not a crime of violence anymore. Attempt to commit robbery by interference with commerce, it's not a crime of violence anymore. The only one left, it's the actually completed robbery. And the instructions, which were jointly submitted, Judge Keenan, the instructions actually do not make a difference as to the 924C charges that they need to find a crime of violence. The court actually attempted to do that in instruction number 54, I believe, where the court says, you know, by the way, the government indicted this case. And if you look at the
were the attempts and conspiracy charges used as predicates for 924Cs?
No, actually, 2 of the attempts were used as predicates, and they were dismissed at trial. Actually, one of them was dismissed at trial. The other one was dismissed, I believe, before trial. And one at trial, another one was dismissed because the fellow testified that it was a BB gun rather than a real gun. So,
but his only convictions for 924C were predicated on actual robbery.
That is correct. That is correct. And the court actually, at instruction number 54, attempts to say that only those 6 convictions or only those 6 charges underlying what is a crime of violence. The judge said you have to have robberies. Robberies are defined in instruction 44. Also, instruction 44 says that an attempt to take could be a robbery. And then in instruction 55, the one subsequent to instruction 54, the jury instruction tells them that all the substantive Hobbs Act counts are crimes of violence. Instruction 55 specifically says counts 1 through 13, which includes the 2 attempts, and 16 are crimes of violence. They're not anymore. Attempted use or threatened use of physical force is a crime of violence. That's not correct. Use of physical force is a crime of violence. Attempted use is not. And further,
But you, excuse me, sir, but
yes, ma'am.
But you presented these to the court to be read to the jury, didn't you? You and the government?
We jointly presented. Yes, ma'am. We jointly presented.
Okay. I mean, it just seems to me that you're putting the trial judge in a really unfair position. I mean, here you're standing by these instructions in front of the trial court, and now you're saying they were so defective that pretty much anybody who knows anything about the law would have been able to discover this. Well, how can you have it both ways?
But what I'm saying, Your Honor, with all due respect, is that the law changed so fast that it was difficult to keep up with it. And I'm also saying that unlike the Simmons case, was decided by this court about waiver by a jointly submitted instruction, which merely dealt with Pinkerton liability theory, this is a different matter where the government uses predicates for the 924C conduct, which was actually one of 3 prohibited conducts under the statute, where in fact, only one can actually stand as a crime of violence.
Okay. How do you get to the miscarriage of justice component of the analysis when you have a co-defendant in this case testifying, essentially delivering this defendant on a platter?
Well, that is correct. We had several co-defendants testifying. And
But there was somebody testifying as to this defendant, Mr. Robertson's participation as to each robbery. So how do you have a miscarriage of justice here?
Well, that co-defendant, and I know that this is an argument that I'm swimming upstream against because I lost it twice. I lost it with the jury and I lost it under Rule 29. But I submit respectfully that co-defendant's testimony was completely devoid of any detail to substantiate the gravamen of the offense of robbery.
Right, but on appeal, we can't reweigh the credibility of the witnesses.
That is correct, George Agee. And I'm not asking you to retry the case as to the testimony of that co-defendant, or I guess, although I raised the issue, I abandoned it with Judge Richardson told me, go to the best ones, as to the sufficiency of the evidence. But that
you may want to stick with that thought and keep going.
Yes, sir. But that insufficiency perhaps can actually require, if it was my error or my invited error, which actually come back on a 2255 at some point in time, I probably will. And then it will be another analysis.
I don't want to belabor this, but let me just ask. So I'm having a little trouble understanding because count 14,
yes, sir.
Right, which is the first of these 924C counts, it specifies that it's only talking about the robbery, right, at a particular location, right? So there's no question that it is a robbery, right? It's not that this is an attempt or a conspiracy, right? It is the robbery. In this one, the Shell gas station,
yes, sir.
Right, on December the 6th. So it's count 14 is this specific example, and that is a robbery, not an attempt.
Yes, Your Honor. However, what happens is this, and I'm sure that the government is going to argue that these attempts were submitted to the court as robberies, but the indictment, all the indictments charge the same language, whether it's an attempt or a convict or a completed robbery. They charge the same language. The special verdict form, which is different than Gillespie, and Gillespie, sorry, I run it. If I can finish.
Yeah, finish your answer, please.
Yes, sir. In Gillespie, there were 27 pages of special verdict forms, and here there were much less. The special verdict forms also describe the offense as interference by commerce, by robbery. And I will argue later on, we weren't even had to prove the stipulation issue was actually waived by the court, saying you have to stipulate to what the first lawyer stipulated, so the government doesn't even need to prove nexus. So the indictment doesn't differentiate between robbery and attempted robbery. Special verdict form doesn't differentiate between robbery and attempted robbery, and none of the instructions do. Thank you, and I will reserve my time.
You've got some rebuttal time. Ms. Bacara, did I pronounce that correctly?
Good morning, and may it please the court, Jacqueline Bashara for the United States. I'll take my friend's arguments in turn. To begin, the speedy trial claim is waived under this court's precedent in Mosteller and under the statutory
Can
language.
you pull the mic a little bit closer to you or speak up just a little bit louder?
Yes. Judge Keenan, can you hear me all right?
Yes, thank you.
Okay, I've had trouble over the Zoom and the mic, so thank you. All right. The speedy trial claim is waived under 3162A2 and Mosteller. Just for the court's frame of reference, my friend suggested that there was no case law on point because the COVID-19 pandemic was, of course, a novel emergency, but I'll note that plenty of defendants in the Eastern District of Virginia properly moved to dismiss their indictments before trial based on speedy trial delays resulting from the COVID-19 general orders continuing cases. We have multiple appeals pending where those claims were properly preserved by a motion to dismiss to the extent the court is concerned about that. I'll turn next to the instructional error. As both Judge Keenan and Judge Agee observed, any error here was invited because the defendant joined in the jointly proposed jury instructions. And I'll note my colleague suggested that the law was sort of in flux because of this court's decision in Taylor. I don't think that's the correct way to characterize what happened here because just for reference, the court decided Taylor on October 14th, 2020. The parties jointly proposed initially their joint instructions on November 3rd, 2020, which was after Taylor. And again, they resubmitted jointly proposed jury instructions on February 11th of 2021. In other words, there was plenty of time to assess the ramifications of Taylor. So under this court's precedent in both Simmons and Mathis, this error was invited. And I'll just note that the court's concern in both of those cases was that the defendant, or at least counsel, had an opportunity to correct the error before it occurred, right? To bring it to the trial court's attention. As Judge Keenan, you noted, this is somewhat unfair to the trial court to be objecting to the error at this late stage. And given the multiple instances in which the instructions were proposed, there was also an opportunity to object, of course, at trial. After the charge was given to the jury, defense counsel did note for the court that instruction 42 still improperly listed counts 17 and 19 and asked the court to strike those counts, but otherwise said, quote, the instructions are adequate. So this is a clear instance of invited error. Even if the court reviews for plain error, as Judge Richardson observed, the defendant simply cannot establish that any plain error affected his substantial rights. Mere uncertainty as to which theory the jury relied on is insufficient. We know that from cases like Ali. The defendant must show that any error in the instructions actually resulted in his conviction. I don't want to belabor the point, but I'll just highlight a few specific instructions. So instruction 44 included a chart which distinguished between counts 6 and 10, which were attempts, and then the remaining robberies, which were completed robberies. Instruction 46 properly defined robbery as the unlawful taking or obtaining of property of another. Instruction 54 told the jury that the underlying crimes of violence.
To rub those, like when I read the indictment in count 6, as your colleague suggests, right, it says that the defendant did unlawfully take and obtain property, right?
Yes.
So it's not an attempt, is what I'm saying, right? It doesn't describe that as an attempt.
So all of the robberies, so counts 2 to 13 and 16 charge that the defendant did obstruct, delay, and effect, and attempt to obstruct, delay, and affect commerce. So the government permissibly charged conjunctively and simply proved those two counts, counts 6 and 10, in the disjunctive.
But it doesn't actually do that, right? Because it then says, in that the defendant did unlawfully take and obtain property, right? So that's not an attempt, right? They did actually take it. And so, I mean, if I was reading that, I would think that's an actual robbery. not an attempt. Help me understand why do I read the indictment? I mean, I'm not sure all this matters given the posture we're in, but it is a little, I mean, your colleague has a point. It is a little confusing that you've charged an attempt by saying did unlawfully take and obtain property. That doesn't sound, I mean, you know, you can charge in the conjunctive, and the defendant did unlawfully take and obtain property and attempt to do so by obtaining United States currency. So you could have charged in the conjunctive.
So I understood that the attempt to obstruct, delay, and affect commerce sort of could carry over, but I understand the court's concern. I think the rest of the jury instructions, of course, the court reviews the instructions on the record and the special verdict form altogether. So that alleviates, certainly on plain error review, any basis for relief here. The last thing I'll note as far as the instructions, I'll just add there was overwhelming and uncontested evidence that the robberies that served as the predicates for the 924C offenses were completed based on the testimony of co-defendants, the testimony of employees at each of the businesses that were robbed, and the video surveillance evidence. Unless the court has any further questions for me, we'll rest on our brief. Thank you.
Judge Keenan, do you have anything else?
No, thank you.
All right, thank you very much. Mr. Grun, you've got some rebuttal time.
Yes, sir. Try to be brief. As to the question Judge Richardson asked, he is absolutely correct. Count 10 is charged the same way. So later on, when the government says in the brief and the court says these are submitted as attempts, maybe they're submitted as attempts. That may be an amendment, an improper amendment of the indictment.
Did you object to that or raise that before us? It's constructive amendment argument. Right, because you jointly proposed the instructions that it is an attempt.
I did. Well, actually, I jointly proposed the instructions that were given. The indictment charges a completed robbery on both of the attempts, counts 6 and 10. And those attempts are not crimes of violence. And when the instruction says that they're crimes of violence, that is error. Whether it's plain error or not, I submit that is plain error. That is an error.
But neither 6 nor 10 served as predicates for 924C.
That is correct. In other words, they were not given any binding instructions for them. But the jury could have believed, in this case, that.
But why would it matter if the jury believed that 6 and 10 are crimes of violence, right? Where they're not predicates for 924C.
For this reason, Judge, if I may, because the jury may believe that since attempts are crimes of violence, it doesn't matter whether it's a completed crime of violence or not. If it's charged and it even is an attempt, we have to convict because it's a crime of violence. In other words, if they had
the other 1951 Hobbs Act robberies were charged as robberies and charged to the jury as robberies, not attempts.
That is correct. That is correct. And the Hobbs Act was actually charged as a conspiracy to commit, to interfere. And if you look at the verdict form, it says interference of commerce by robbery. Doesn't say interference of commerce by attempted robbery. Later on, when the description of the place and the date is given, it says attempt. I'm not sure that anybody can make a difference of that because we're telling you it's the same thing, telling you it doesn't matter, and it's telling you, it's interference of robbery by commerce by robbery. And then the last argument I want to raise to the court is during the first trial, which was a couple of years earlier, and I was not the lawyer for that, it resulted in a mistrial. At that trial, which was all the Hobbs Act counts, all the gun counts, and the felon in possession, prior counsel raised the stipulation and reached its stipulation with the government saying, we stipulate to all these things. At this current trial, last year, 2 years ago, where we are actually arguing now, that resulted in all the sentences, Mr. Robertson indicated he did not wish to stipulate to interstate nexus. We objected to that stipulation. The government asked the court to enforce the previous stipulation under a different lawyer of a different case about 2 years earlier. The judge agreed and enforced that stipulation, saying, once you stipulate, you got to stipulate it's not an important part, it's something that is not at issue. Well, it is at issue. Any robbery across the street, unless there is interstate commerce or foreign commerce involved, is actually strictly a state matter. Here, and it will not.
You pointed to the Capitol and the legislature.
Well, I pointed to I jumped over the federal courtroom to the courthouse, so I'm going on the other side. So any robbery of an individual of money, not of drugs, because of drugs will bring me here, but of money, it's actually state. And if I have a gun, I will go to the state court with a charge with a felon in possession or a gun charge. So, but not the federal court. I submit to the court that it was an abuse of discretion of the district court judge to actually force that stipulation upon Mr. Robertson, where it actually, in essence, guarantees federal prosecution. The government has charged this as an interference with commerce that actually interstate commerce. And by being relieved of showing that nexus, which Mr. Robertson duly and properly objected to, it basically makes the witnesses that Judge Keenan was talking about that didn't really remember much, all they were doing, she's talking about Mr. Ellison. He was showing a picture. There's a guy with a mask and a gun. Yeah, that's me. That's my mask. That's my gun. What do? I robbed the clerk. He didn't remember dates. He didn't remember places. He didn't remember money taken. He didn't remember much. Once they don't need to bring a witness who was robbed.
So what did you tell the trial court was the error in terms of the stipulation?
That we objected to that stipulation and that we required that Mr. Robertson required a factual witness to come over and say that whatever that business is, sold bubble gum or sold gas, that all those travel in interstate commerce and did affect commerce, because the indictment and the instructions and the verdict form says.
Our cases seem to indicate that you'd have to argue on stipulations that there was either a manifest injustice or a mistake of law, and I don't think that appeared in your brief.
Well, Judge, under the Lentz case, which the district court relied on, and so did the government, was a stipulation on the same charges that had been tried before. This case is a different matter. We objected to the stipulation. We actually required the government to prove that. The judge denied our motion, and then we signed the stipulation because the trial was about to commence. There was nothing else we could do. So I think the manifest injustice has resulted. Thank you.
All right. Thank you very much. We appreciate the argument of counsel. Mr. Grun, we particularly want to thank you because we know you are court appointed, and if there were not individual counsel like you who would agree to undertake those tasks, we could not perform our function and could not render justice. So we particularly appreciate your agreeing to act in that capacity. So we're going to come down and greet counsel. The clerk will adjourn court. We'll stay here for a short while to talk with the students. And Jackie, am I correct? In order for Judge Keenan to see us, we need to be seated up here. All right. We'll come down and greet counsel after you adjourn court.
This honorable court stands adjourned. Sign and I, God save the United States and this honorable court.